All right, good afternoon, everyone. We're here for the pretrial services work groups, part of the Incarceration Prevention and Reduction Task Force. Looks like we have a quorum, which is good. And I think maybe I'll start out with Judge Garrett, if I could. I know Judge Garrett had some. Did you want to start the meeting with anything, Deborah? Oh, you're muted there.
There, is that better?
Yes.
Yeah, okay, I'm sorry. I'll start with my own news, and I have another topic to follow up on from last month. But my own news is that I'm going to resign from this committee. I think Judge Jones has things well in hand, and I think that my presence is no longer needed. And frankly, my expertise is fading as I've been retired for 3 years now, and the court has undergone a lot of changes in that time. I want to thank everybody who's worked on this committee. It's been a long time and longer to bring things to fruition than I think any of us had contemplated when we started way back in, yikes, I think 2018. But I've really enjoyed working with all the people and on this committee and hearing the different points of view that people bring and hearing about the interesting projects that people are working on. So I want to thank all of you and hope that Bellingham's not a real big town. Hope that I run into you in the course of things around town. That's my news. I also just wanted to transition into the discussion today by reminding everybody that we had a really good discussion last month about how we're going to define the term violation for pretrial services unit purposes. And I'm hoping that we can follow up on that discussion today. Again, thank you all.
Just wanted, maybe I know an important part of that, Deborah, was that you've assured me that you're 100% available for anything that might, need to bring you back in, or conversations I might not want to have with you, those sorts of things.
Absolutely. Absolutely. And that's true for Judge Jones. And also, if anybody else on the committee wants to contact me and talk about anything or whatever, I'm not going anyplace. So just let me know. Great. Okay. Maybe that finishes my participation in the committee. Unless anybody, excuse me, unless anybody has a strong objection, I think I'm going to let Judge Jones take over the moderating of the meeting and sign off. Again, thanks to everybody on the committee. Your work has been very good.
I just I want to say for my part, I don't know, maybe other people have something to say, but I just want to I just want to say I know, Deborah, how hard you've worked and how important the work that you put into this has been since the time that you did it, and I know from your perspective and others, it's been kind of a rocky road in large part because of COVID and the effect that had on our populations and our programs, but some other employment things that we had going on, but I really feel that when I came into this discussion, I really felt like the pieces are in place to really do something important through our pretrial services department, and that's entirely because of your efforts. So I just want to say thank you for putting us in that spot.
Yeah, I want to just add a little bit to what Judge Jones said, and that you recognize the importance of this work right out of the chute, and it was so refreshing to have you spearhead this group for the past several years now. And I am so grateful that you did this for us. And thank you, Deborah. We really appreciate it.
Oh, thank you, Barry. I appreciate hearing that.
And I think it's my turn to chime in, since I was here from the beginning with Judge Garrett. And I'm just recalling from the start, this was not easy work. There was a lot of ground to be plowed with the judicial officers and with the task force to sort of coordinate and to focus on the right topics at the right time. And I think your leadership was indispensable for us to make what progress we have made and to sort of tee up the other issues that we need to tackle to make further progress. So we wouldn't be where we are without you, Judge Garrett, and thank you.
Thank you, Stephen. Thanks to all of you who've said such nice things about me. I think it's important to remember, though, that from the beginning, this has been a group effort, and this group has very much benefited from the different perspectives that various people have brought to it. So yeah, we've made some accomplishments, and we've done it together. So good for us. I think that the way from here is very promising. Okay. Judge Jones, I think I can hand the, I don't know, the gavel or the microphone or the
Proverbial,
mouse
yeah,
or something over
the
to
baton.
you. Okay. Once again, thanks to everybody for your participation in this group, and I'll be easily available and watching to see how things go from here. So thank you all. Bye now.
Thanks, Deborah. All right. Well, Deborah had told me that last month, and I wasn't able to be here last month, so I know she kind of thought about that decision and hung on to it for over the course of last month. But we talked again earlier in the week, and I know she just felt like it was an okay time to do that, both in her life and in the life of the committee. So now we have the obligation to make it work for her and everyone, for her and the programs and everyone else. All right. So as far as what we need to discuss today, Deborah had told me, I wasn't here last week or last month, but Deborah had told me that there was a good conversation about how to determine successes in the programs or define failures in the program. So I don't, maybe it's helpful. I sent out, Alan Epps and I have been working on policies that kind of sound similar to that question. And so I sent out this proposed draft policy about how the program, the Pretrial Services Department is going to appreciate violations, and then what the consequences of those violations will look like, how they'll be handled by the Pretrial Services Department. So I guess what I'd like to do is invite any conversation or feedback either about that discussion from last month or the kind of how we're looking at defining those things through policies.
Well, I can chime in a little bit, Judge Jones, about how I even created this in the first place. So I was using a lot of the trainings I've taken through APPR and through other NAPSA and through other kind of front runners of pretrial services. And I also use Thurston County. They've been very generous with sharing some of their, I guess you could say, procedures with me. And I kind of took a little bit of what I've learned through all the trainings I've been taking, as well as how they do their violation grid or their responses to said violations. And I created this. I think it makes more sense than what they sent me. This is more, it's just clear, more concise, you know, if this happens, then this shall happen. And so that's how this kind of came about. Some of the things in here might draw some questions, or, you know, is that where people would consider it to be not trivial, it's what I'm looking for, punitive. Some of the responses might be too punitive for what we're trying to accomplish in this work group. But I guess that goes hand in hand with what you were saying with starting a discussion of which of these items might be left off, or which I saw that you put a star on it that says request issuance of a bench warrant. So I think there will still need to be some fine tuning on this. But just so the committee knows, I wasn't just pulling this from thin air. I was using Thurston County and kind of best practices with the trainings I've been doing to create this.
Alan or Jill, perhaps can we share the notes again so that we're looking at them as we talk about it a little bit?
Yeah, I can screen share this.
Thank you, Jill.
Do you all see it?
Not
Yeah.
all.
Could you scroll down a little bit, Joe?
Better.
So Alan, maybe you can walk us through kind of how I know you pulled this from some other sources, but just the idea is that we're kind of segmenting different severities of violations, minor, moderate, severe, and just kind of what the thinking is about that from your trainings or who you've talked to.
Sure, I'll do my best to kind of paraphrase or to explain it. So national standards are that you don't want to be too heavy-handed in pretrial services. They've actually had recent studies, which I could try to find for us, that show that the amount of office check-ins, for instance, if we're requiring somebody to come in the office once a week or twice a week, that doesn't necessarily have any bearing on whether they're going to commit a new crime. They're finding out, which I suppose it's not that surprising to me because behavior is behavior. So it's kind of a balance between being too heavy-handed and just not being heavy-handed enough, just letting everything go. A lot of, like, for instance, the minor violations, missing a pretrial appointment, response might be to try to reschedule the appointment, call the defendant, or excuse me, the client, try to see if they have another number, email, try other avenues to get them back into the office, or to just get them on the phone and let them know that their court date's coming up or something along that line. A new alleged traffic offense, I see that you also put that it could be, scan or noted in CE or in our software and report it to the parties just so they're made aware. I like that addition. I don't know for certain if other jurisdictions do that for traffic offenses. I'm not sure. With your line of thought, I'm not sure what would be the benefit of letting, let's say, the prosecutor know that they got a seatbelt violation. But I'm not saying we shouldn't do it. I guess I'd want to know what the benefit to, if that'd be too punitive. And then obviously it goes all the way up to the moderate would be, missing multiple appointments. Well, now you're running the risk of losing this person into the system, or excuse me, losing them and them at risk of getting a failure to appear, or kind of forgetting that they have a case and not being as careful or trying to get through the process through the court system. And then all the way to severe would be that they're completely out of contact with us. They don't care about us. They violated let's say a protection order through a new charge, or they failed to appear at a status calendar when requested, or they're flat out just kind of in the wind, so to speak. So that as you go from left to right, I think the action, or excuse me, the client's action and our response is appropriate. So I tried to go to reflect that. I tried to reflect that it does go from more punitive to more serious offense, all the way down to requesting an issuance of bench warrant, because they pretty much are in the wind.
Yeah, one of the thoughts here too, and the notes you see in pen are mine, and that's just because this was the only copy I had, and I made some notes on it for myself, so they're not. That's what you see there. That is just my thoughts that are probably indecipherable. But another kind of important thing from my perspective that I think a grid like this appreciates, and is that it puts all the part. We have to have. There needs to be buy-in to this program from the parties to the litigation. So, in particular, the prosecutor's office needs to be some effort to convince them that there's monitoring going on, and that there's information being shared about appropriately about how somebody's doing in the program and what they're doing with the help that's being offered with them. So it is meant, a policy like this, in my mind anyway, is meant to kind of also make clear what exactly the program is going to be doing so that the parties can rely on those actions as far as the cases are concerned. So things like noting the file, filing a notice that new crimes have occurred, or we're not doing anything in court about that. We're not issuing warrants or putting them on court calendars or doing anything like that, but we're providing the information as a court to everybody.
Yeah, I would agree with what you're saying as far as a lot of this isn't meant to throw them back in jail or to issue a warrant or to start the process all over with them again. It's to, I think you said it best with buy-in. It's to let them know that. So I hear a lot, not so much anymore, but I used to hear a lot at first appearances from the prosecutor's office that, well, all we do is send text messages. Well, I don't see why you're going to put them on Medium if all we're going to do is send a text message. What if they don't have a phone? Well, that's fair. But if we can show them kind of this grid and say there's more than just text messages that are being sent to try to ensure compliance, or try not necessarily compliance. We're not talking about compliance. We're talking about appearing in court, community safety, and trying to prevent, hopefully, which it's difficult, like I said, commission of a new crime. Those are the three things that we're focusing on. So if the parties, namely the one that he was mentioning as well, the prosecutor's office, can see that it's more than just text messages, it's more than just office check-ins, that there can be a response or at least a notification to all the parties, I think it will ensure some type of, I guess, dare I say, trust in what we do.
I think if I'm understanding this correctly, this is looking at the process solely from the pretrial services unit perspective. Am I right, Alan?
Correct. Yeah, this would be the process we take if these things happen within our expectations of the program.
So I haven't thought through this entirely, but I think we've made a shift here that I'm not sure is a good shift. And it just struck me when you said at the outset of your remarks, Alan, having them check in person once or twice a week doesn't look like it's effective in the evidence to preventing new crimes. And what I would say is there is no expectation that pretrial services will be effective in preventing new crimes. The court has made a judgment, a risk assessment judgment, to release this person rather than hold them under certain circumstances. And the more they comply with that, the more they can follow through with their case from the community. And the less they can follow, the more the court looks at that information and may want to reconsider that. So it really is more like Judge Jones was saying, that it's a flow of information, but the focus of that flow is really the court and the parties to the case. So I don't find any of this too punitive. I guess part of me wonders whether it's punitive enough, but that really is a judgment for the judicial officer. And I don't think the pretrial services unit should hold back on circulating as much information, including new alleged traffic offenses, amongst the parties.
Carol, well, I just wanted to respond to Stephen real quick. And another thing Alan said, which is a dynamic here for everyone. And so maybe if Alan wants to comment on this, is there's an element of success and one of our primary motivation in pretrial services is to assist the person and with services that they might need. to move through their court case, but a lot of times that looks like things they might need in life. And so there is a dynamic where Alan it has to develop trust and respect of individuals, of his clients. And so to the extent that he's viewed by them sometimes as tattling on them or getting them in trouble, sometimes a flow of information can be detrimental to that. Is that true, Alan, that relationship?
Yes and no. And if Jake, I can't see if Jake is still on the screen. I don't mean to put him on the spot, but I guess I would have to call on the expertise of like a probation officer, for instance. And I know there's a fine line, or I should say, I don't know how fine it is, but the line between probation and pretrial, what we're doing. But I guess you can still have rapport and you can still be respected and you can still be very upfront with your client. In my experience, if you're very upfront with them and you let them know that you'll be not necessarily enforcing, but letting them know that we're, watching things like criminal history. We're making sure that you show up to court. If it, we're notifying the parties if you don't. I think respect and the trust goes a long way if you just let them know what they're going to expect. Now, if we're filing notice of alleged violations and we're trying to do everything kind of behind the curtain, secretly behind them to get them in trouble, I think that trust is completely broken down. I don't know if Jake can speak to that at all.
Yeah, all I can say is that relationship is part of what I miss so much now, not being able to do that. And that's what I appreciated so much. I think it all comes from the beginning when you meet with them and establishing that rapport and letting them know, we want to see you succeed. That's why you're here. That's why I'm here. But we follow your lead, right? You do well, we're gonna be standing here on the side, just kind of giving you the support, the guidance, the referrals you need. But if you make those choices to get the new, whatever offenses or whatever that might be, we have to take action. And, just making that clear from the get-go. Yeah.
Yeah, thank you, Jake. Did that answer your question, Judge Jones? I don't know if that's kind of what you were alluding to. Okay. And then Carol still had a question.
Oh, thanks. Yeah, I was just wondering if you could walk us through like the steps and the flow of information and the timeline, like specifically for the severe violations column. And I'm wondering how different that might be. It looks like there's a few different circumstances that end up in that column. There's the person has kind of disappeared, is not checking in with pretrial services, maybe is not showing up for court. Like what happens under those circumstances, or they have new significant charges and maybe that's a different pathway if they're in jail on new charges, or if pretrial services becomes aware that there are new charges and they're not in jail. So kind of for each of those, disappeared, in jail on new charges and not in jail, like what happens and what's the flow of where information goes and what decisions would get made?
Sure. Yeah, I'll try to do it as condensed as possible. Because to explain it might take a little bit longer, but I'll try to keep it short. So let's say for the first one, let's just go by the order here. Unable to be located by pretrial services. So for instance, people right now directed to high are current standing. Last order signed by Judge Olson was that people assigned to high have to check in with our office once a week. And so if 1 week goes by, we we just do a failure to report in the office and we find other ways to try and get a hold of them. We try their phone, email if they've given it to us. We'll send a letter to their home address or to any address they have listed, really. We can use Odyssey and Jabs for those addresses as well. And then if week 2 goes by, we note it as a failure to report again. But at that point, we might also send a failure to contact pretrial services. So that's not necessarily a violation. It's a technical violation, but it's not a notice of alleged violation. And the important distinguishing factor between the two is one, well, the prosecutor could take action on either of them, but one form actually has boxes that show, what the judicial officer who's presented the order can do. So for a failure to contact or to failure to stay in contact with pretrial services, that's just a notice we send to all parties. So it's just an informational sheet that says said client hasn't been in contact since this date, they're on high pretrial services, and we just send it to everybody saying, yeah, we're noticing that they're getting harder to get in the office, or that it's harder for them to get in the office. If that continues, our current, I guess, standing practice is after 30 days, if somebody who's assigned a high level of pretrial services has not made any attempts to contact the office, either through text, email, in person, phone, family member, treatment facility, if there's been no attempt to stay in contact with our office, then it becomes a notice of alleged violation. And that is describing, more detail about, said client is on high level of pretrial services assigned on this date. They've failed to stay in contact when we've attempted on this date. And so we list the dates. And then we present that order to a judge or a commissioner, excuse me. And they can make a decision on schedule a hearing, refer to prosecutor for further action, take no action, or issuance of a bench warrant. And then when we get that, whatever box they check, we scan it into our system, we stamp it in Superior Court office behind us. We file one copy with the prosecutor's office, and we send one copy to the defense attorneys, whether it's private counsel, conflict counsel, or public defender's office. And then we file one with the clerk's office, so it's scanned into their permanent file. From there, depending on what box they checked, but in most recent cases, it's been refer to prosecutor's office for further action. From there, it's up to the prosecutor. If they want to note him up for a bail review hearing, or just a review of conditions hearing, or whatever. So that's how it would be like if they're unable to be located. The other ones, I see Judge Jones drew a line between the new charge, or he wrote new charge ? Between failure to comply with protection order and new alleged felony or misdemeanor charges. Those probably could be condensed, because we wouldn't know about a violation of protection order unless they picked up a new charge technically, because we don't do GPS monitoring or things like that. And those would be straight to a notice of alleged violation. So the commissioner would have to make a decision on that again. And that would be filed with all the parties that I mentioned before. And then a failure to appear in court, if it's for a status calendar, we just make note of that in our software. But if they fail to appear and a warrant was issued, then they're removed from pretrial services. Stephanie, did you want to follow up on what I was saying about that?
I guess I have a comments. I'll say comment for the group. The one thing as I'm looking at this that I'm thinking about is none of this takes into account that there was a risk, like the risk level. So if they were put on high pretrial, the judicial officer decided that for a reason. And that would lead to me, if I'm thinking about, they put them on high because of, I would say, community risk. So that would indicate that potentially my response should be different or quicker. Maybe quicker is the better word for violations for that group of people. So I don't really see how the risk level for when someone, like the risk level that someone is assigned on pretrial is really taken into consideration with this particular grid.
That's a good point. There may need to be some adjustments then that can reflect different levels. Thank you.
Stephen, do you want to go?
Yeah, thank you. I guess I feel like that Hindu proverb of the 8 blind men trying to identify the elephant, and I think this sort of gives us a grasp of the tail, but and I know we're advisory, but I don't see how we can do oversight without, I think Stephanie's point is right on that the risk level should be something we can track through this. I also think this sort of stays in the silo of the PSU. We don't know how many of these things actually, we don't know what box got checked by the judicial officer. So we don't know if it got referred to the prosecutor. We don't know what portion of highs, moderates, and lows got referred to the prosecutor. We don't know how many of those the prosecutor took any action on, noting a hearing or otherwise. And so I don't think we understand how we're operating, or how well we're operating, I guess is what I would say. And I know there's discretion in all of that, and we can't tell the prosecutor or the judicial officer to give us data on that, but it sure would be nice, and it sure seems within our scope of responsibility to be able to make informed assessments of how well we're doing with this if we had data like that. So that goes beyond, I think, what Alan can provide us, and falls into the laps of other parties in the system. But I personally, I think we need that kind of information.
Yeah, I think both those comments, both Stephen's and Stephanie's, are right on. And something Alan and I will talk about and should talk about. Like you pointed out, Stephen, too, the data tracking piece I think is incredibly important, and probably you're right, beyond the scope of what Alan can track just based on kind of what happens next. After information's provided, the court would have to be involved in recognizing when something's before us on a pretrial services notification. And then what we do about it. We could at least then make some inferences, well, we could at least then see what matters are being brought by the lawyers to the court's attention and what aren't. I think that could be important.
Thank you.
Yeah. All right, any other comments? And people do appreciate the big word draft across here, and I this group's important to me personally for that reason, just to hear whether we're even in the same room as the elephant or not. So appreciate that.
I just want to thank Alan for putting this together. I think it really helps us think about, these kinds of things and risks and so on, and gets it right there in front of us. So thanks, Alan.
You're welcome. Thank you.
All right, unless there's anything else about that, I guess I'll just, I don't have another item on the agenda. So maybe, is there anything else anybody wants to discuss or needs
We do
discussion?
have, Jill here, we do have Stephanie's report on the AOC grants.
Great. Thanks, Jill.
Hello, everyone. We did receive an award increase, which I believe the letter should have gone around to everyone showing that from AOC. AOC is still working with their contract team to determine what a contract would look like. What I have been assured is that funding that we had earmarked, for example, for the NAPSA conference, which is next week, so we wouldn't be able to use it for this year. We are able to move it around to one of the other areas we identified, but they have not been able to articulate whether we're tied in, like amount wise, what we had proposed for those areas, or if they're going to allow us the flexibility within our proposal to move funds to meet our goals and needs as we go forward and continue the work that we're doing. I should hear more, they said, hopefully in the next couple of weeks with the actual contract, that we can have that conversation differently with them. What I do know is anything that's within our scope that we proposed, that has had a cost, like for example, we purchased more bus passes last week, we are able to ask for the reimbursement for those goods. And then what they are also working on is a pretrial kind of summit that's on September 26th. And Alan, Kelsey, and I will be attending that. That's all day, and that will have the other Washington State pretrial groups will have also been invited. And it's a mini Washington kind of centered version of the NAPSA conference that we weren't able to go to. Part of that will be looking at best practices, which I think will be really helpful for us as we continue to look at things such as the draft policy and procedure we just looked at, and also to follow up on our conversation last week about data collection. So they'll have more information for the groups at that time about what data AOC is wanting and how that fits within the best practices that they're supporting the courts that are participating in a pretrial program with.
Thanks, Stephanie. Anyone have any questions for Stephanie about those funds or her efforts there? All right. Okay, anything? Oh, Stephen has a question. Go ahead, Stephen.
Thank you. I have two questions actually, if I could pack them together. One is Alan mentioned APPR earlier in his comments. That's advancing pretrial policy and research. And I think it started out with the Arnold Foundation that developed the PSA. It may be independent now. But in any event, they circulate a lot of research. We talked recently, and Alan's statistics show that a vast majority of our pretrial releases come with bail attached rather than personal recognizance. And they just put out a study, a pretty extensive study that shows pretty conclusively that bail has absolutely no benefit for preventing failures to appear or preventing new criminal activities. Now, that would need some study on our part and some discussion. But so first off, I'd just like to ask the group whether I could forward that to Judge Jones and Jill for circulation, both to the work group members and to the other judicial officers. I know we talked about taking this back behind the screen and having a conversation with the judicial officers at some point about their inclination to do that. And I don't want to overstep my bounds as a work group member. So I'd just like to know whether that would be a valuable piece of information to circulate amongst us to look at and think about.
I'd say the answer to that from my perspective is yes. I'd like to look at any of the data that is available to be looked at. I don't see that as a negative in any way. It's a good thing. So
okay,
I think the discussion then, there might be a further discussion of what's the appropriate way to approach the rest of the bench, but it's a good place to start.
Absolutely. I just put that in your hands. The second thing is, Alan, I appreciated your giving us the numbers chart cumulative for the year that you had Jill send around also. I noticed that most of the people in pretrial services are high and the next most are moderate. I'm just wondering if you have a handle on what are the factors that are putting people in those categories. I'm a little surprised that there aren't more lows there. And so I know that's the characteristics that come before the judicial officer. I'm just trying to understand how that scoring plays out into the tiering of the pretrial release group. Can you speak to that at all?
Not really. Well, I can, but ultimately it's up to the judicial officer what level to choose. So if you go, if you're looking at that form right now, for instance, the PSA is completed. So let's look at July, 122 are completed. 75 were high, 25 were medium, 22 are low. I mean, and you can go back basically till January and see that a majority of our referrals, thank you, a majority of our PSAs are coming up high, and that has to do, as you know, it's a 9 question. The PSA is 9 questions. You know, are there any pending offenses at time of arrest? Do they have any misdemeanors? Any felony convictions? Any sentence? So any sentences, anything over 14 days? Any failure to appear within the last 2 years, and any failure to appear older than 2 years. So I just, Kelsey and we just complete the PSA, and that's how the numbers fall. So it's not any surprise to me that we have more people referred to high level. Now, that being said, we could have somebody that scored high because they have not really any crimes in their history. Let's say they don't have any pending charge, they don't have any felony convictions, but they have, let's say, a misdemeanor conviction, 1 sentence for a, probably that same misdemeanor, and then they've missed 2 court dates in the last 2 years. Well, they might come out high just because their likelihood of failure to appear is high, which bumps their score up. The judicial officer might look at that and say, based on their discretion, say, yeah, I see it comes out high, but I think this person needs services more than, the high pretrial services. They just need the text messages, maybe once a month, reminders that we're still here, updating their phone or their address or something like that. So even though somebody scores high, they might be referred to medium or low, just to help facilitate them get to court. So to speak about why we're higher, it's just the way the PSA is scoring people. And so that's our actual caseload will reflect that as well.
But actually what you just said is it's not the way they're being scored, in a crude formalistic way. It's the way the judicial officer is processing the multiplicity of factors on the score sheet. So it seems more likely from the numbers that the judicial officer is taking a moderate score and saying, I think we ought to have a little shorter leash on this person. I'm gonna refer them as a high.
That is a possibility as well.
Is there much impact on felony bookings for jail restrictions? Like, are we seeing a skewed high population of people being booked into jail at this point?
I don't know if I can answer that. I don't know if anybody else can.
That was actually going to be my comment. I think one thing to consider when we're looking at Alan's PSAs completed is that the jail through booking restrictions, there's already this pool of individuals that are kind of diverted from this process. And I think that when you're looking at who they're actually booking, it's not surprising, given those factors, that we are seeing our PSAs come out higher. If you kind of look at a little bit at what some of the restrictions are, in terms of when we complete the PSA, and this is the level that it kind of spits out.
That's a great question and answer that really gives me a whole different way to look at this, and I appreciate that very much. Thanks, both of you.
Yeah, I think that's definitely true with the population reflected in these numbers. But another thing too, just from a judicial perspective, is often pretrial services is sometimes used as an escalation of conditions based on how people are behaving on pretrial release already. So, you might release someone on their personal recognizance without supervision, but then they fail to appear, they get a warrant, they come back in, and then you release them again on their personal recognizance, but you add pretrial supervision. And you might be dealing with somebody who's in jail, so they're already of that kind of class of more severe cases, and they're also have a history within their case of not following rules. So you might tend more heavily towards high, moderate supervision for those folks too.
Thank you.
I think one other thing to consider is we have 3 levels we've identified, but we don't have the most recent order about kind of what those levels mean for looking at pretrial. There's really only 2 levels there. So at some point, do we look at having a true 3 different, 3 different check-in levels like that are actually separate instead of where we have 2 levels combined right now, like with frequency and duration. And I know we did way back at the beginning, and then things have kind of changed through COVID, and that's where we sit today with that.
All right, any other discussion about the numbers there or for Stephanie? Okay, anything else, Jill, on our agenda? I don't have it up in front of me.
No.
Okay.
And it doesn't look like we have any attendees, so I don't anticipate public comment.
All right, great. Anything else then from anyone before we adjourn the meeting? Okay, just a reminder when we plan to meet next. Jill, do you have that date?
I do. It is October 4th.
Great.
Right, October 4th.
Alan and I will make some progress before that October 4th meeting. We'll incorporate some of this discussion and maybe continue it at the next meeting. If there aren't other things to talk about, we'll come up with some. And then I'll also look forward to that link to the study that Stephen was telling us about. Look forward to that. Okay. All right. Thank you, everybody. Have a good day. Good weekend.